let's look at some other criteria as to whether something is a contractual term or a mere representation. When whatever is said is recorded in writing, so parties negotiate and certain things are said, and some of those things are recorded in writing, that may serve as evidence. So it's not conclusive, but it's certainly evidence of that having been intended to be a contractual term. And for an authority on this, we could, again, for instance, turn to Oscar Chess and Williams. Now, very importantly, sometimes things that are said may be contractual terms, even though the actual contract says that they are not. So how does this work? Well, a good example of this type of situation is Couchman and Hill. In Couchman and Hill, Couchman wanted to buy a young cow, and he wanted to make sure it was not pregnant, so this was important. The cow was being sold at an auction, and both the owner of the cow as well as the auctioneer said that the cow was not pregnant. So that was the statement. So Couchman went ahead and bought the cow. Turned out later that it was pregnant, and so Couchman wanted to sue for breach of contract. Now, he could only sue for breach of contract if that statement that the cow was not pregnant was indeed a contractual term and not a mere representation. Couchman's problem was that the written contract that he had signed, that means the contract between Couchman and the seller, which was a contract which was a standard contract by the auction house, that mentioned that anything said by the auctioneer during the auction process was not to be considered a term of the contract. That means anything said by the auctioneer, the auction house and the seller would not be liable for that. So on the one hand, you had the contract, which said that things that were said as part of the auction were not binding. On the other hand, you had this statement on which the buyer relied. And so the court said that since this statement induced the buyer, and obviously it was of crucial importance, it was indeed a contractual term, because if he'd known that the cow was pregnant, he'd have never bought it. So here you really have a case that combines a number of these criteria. We have the criteria regarding the importance of a term, we have the criteria regarding inducement, and of course we have the criteria that sometimes statements that are made may be terms even if the written agreement suggests otherwise. Now lastly, on this issue of distinguishing between terms of a contract and mere representations, we note that even though you can show intention, so the intention to be bound by a statement, even where that is present, sometimes you'll be able to rebut that. And we can turn again to Dick Bentley and Harold Smith for that. So this is how the court stated it. If a representation is made in the course of dealings for a contract for the very purpose of inducing the other party to act upon it, and actually inducing him to act upon it by entering into the contract, that is prima facie ground for inferring that it was intended as a contractual term. So this whole notion that if you say something which is meant to induce the other person to go ahead and contract with you, and you actually do that and there is a contract, well then the fact that you said something which induced the other party is very strong evidence of whatever you said being a contractual term. However, the maker of the representation can rebut this inference if he can show that he was in fact innocent of fault in making it, and that it would not be reasonable in the circumstances for him to be bound by it. Now, of course, in Dick Bentley, the presumption that there was intention, or the presumption that intention showed that there was a contractual term, or even that inducement led to there being a contractual term, in Dick Bentley, that could not be rebutted for various reasons, most importantly the fact that the sellers were experts. However, in Oscar Chess, where again the statement about the model of the car, the model year of the car, could be seen as inducement, because the buyer would probably not have bought the car had he known it was a much older model. So even though there may have been inducement, quite certainly there was inducement, and even though we usually say that inducement means that whatever was said was a term of the contract or is a term of the contract, in Oscar, Chess, and Williams, that was rebutted. And it was rebutted because the seller had no idea. The seller was not an expert. And in fact, if you go into the details of Oscar, Chess, and Williams, you'll see that in fact the seller himself had been given a document that misstated the model year, and the previous owner had given him that document. Now, there was some fraud involved and matters that we do not need to concern ourselves with at this moment. But so again, we see that not only do these cases often bring out 2 or 3 of the criteria we discussed, but we also see that even where the criteria that we just discussed suggest that something is a contractual term, that can be rebutted. And for instance, it can be rebutted because someone said whatever they said innocently, believing it to be true. And in those circumstances, that can be rebutted. Now, this kind of leads into another topic, which is called misrepresentation. But misrepresentation is not covered as part of this course. Misrepresentation is part of the Contract Law 2 course. So for now, we merely distinguish between representations and terms of a contract. And to do so, we look at all these criteria, of which we've looked at a number of examples. And by using those criteria and applying 2, 3, 4 of them, we kind of hopefully get to the answer of whether something is a term of a contract or merely a representation. All of these criteria that we just looked at, they relate to things that were actually said or things that were actually written down or things that by their conduct parties in some way expressed. Now, all of those we call express terms. Of course, if they are terms, they may be mere representations, but if they're terms, then they are express terms, simply because parties have expressed them orally, by conduct, or in writing. Now, where express terms are concerned, the problem is not what was said, because we know what was said, or what was written down, or we know about the conduct. The problem is what it meant. Now, often it's not a problem, but sometimes it can be a problem. So we have 2 cases that we can look at to illustrate this. Smith & Hughes, of course, is a very famous case involving the sale of oats. Now, Smith & Hughes is a case of mistake, but mistake is not a topic covered in Contract Law 1. Mistake is a topic that is covered in Contract Law 2. So we're not looking at Smith & Hughes right now from a mistake perspective. We're looking at it from a perspective of an express term that the parties expressed, and it was clear, or at least it seemed to be clear to the parties what it was, but later it turned out that maybe the parties weren't so clear as to what it means. So again, we know what was said, but we may not know exactly what it means. So in Smith & Hughes, the issue was the sale of oats, and the owner of horses wanted to buy some oats to feed the horses. But the only oats that were useful to the owner of the horses were old oats. But what he was subsequently given were new oats. And so the contract said oats. So when you say, when the express term says oats, well, we're clear as to what the contract says, but we're not clear as to what that means. In the end, the courts determined that because the sample that had been given before the contract was formed was in fact new oats, there was a presumption that the contract was indeed for new oats. But the point again is that sometimes you have an express term. We can all read it, we can all see it, but we may not know exactly what it means. So that is the problem with express terms in general. Another case to illustrate this is Thake and Maurice. In Thake and Maurice, there was the Thakes, a couple, and they had a number of kids, and they wanted to basically not have any more kids. So the wife underwent a vasectomy, and the doctor, Morris, said that this was a final procedure. That means it was irreversible. So once you had it, that's it. Now, in the end, Mrs. Thake got pregnant again, and so they sued the doctor. Now, again, the terms are clear. There's going to be a vasectomy, and it is supposed to be an irreversible procedure. But the court said that as a general rule, of course, we all know that medical procedures can go well and can go wrong. That's just a fact of life. So even though we knew what the terms of the contract between the Thakes and the doctor were, we didn't quite know how far it went. We didn't know what exactly it meant. Did it mean that the doctor guarantee that the X were never going to have another child? Or did the doctor not guarantee that? And the court said, well, the doctor did not guarantee that. So although there was an express term, the meaning of that express term was a bit less than actually completely 100% irreversible, because there will always be circumstances where a medical procedure does not work 100%. Okay, so that's the notion of express terms. Usually it's not a problem. Usually we know what they are because they've been written down, or they've been recorded in some way, or there's agreement as to what was said. And all that may be a problem after that is what that meant. So express terms in general are not a big problem. More interesting from an academic perspective are implied terms. That is because implied terms are terms that are in fact terms of a contract, even though the parties have not mentioned anything about them. The parties haven't mentioned anything about them in their discussions or in their final agreement or at any other point in time. Instead, those terms are implied into the contract, usually by the courts. Now, a good case to illustrate the sort of boundary between express terms and implied terms is Trollope and Coles and the Northwest Metropolitan Regional Hospital Board. Now, this is a fairly complex construction case, and it involves contractual terms between the parties, a building company and the hospital, that were seen as being harsh, and they probably were quite harsh. And so efforts were made to lessen the impact of those terms by implying terms into the contract, by implying things into the contract which had not been written in the contract. And here's how the court defined its own role in implying terms into a contract. The court does not make a contract for the parties. The court will not even improve the contract which the parties have made for themselves, however desirable the improvement might be. The court's function is to interpret and apply the contract which the parties have made for themselves. So again, all of this goes back to the notion of contractual freedom, which of course is a theme throughout this course, because almost everything we do can be traced back to the freedom to contract. So generally, parties agree whatever they agree, and the courts merely apply that and sometimes interpret that. But it's not the court's role to rewrite that. The court goes on. If the express terms are perfectly clear and free from ambiguity, there is no choice to be made between different possible meanings. The clear terms must be applied even if the court thinks some other terms would have been more suitable. An unexpressed term can be implied if and only if the court finds that the parties must have intended that term to form part of their contract. It is not enough for the court to find that such a term would have been adopted by the parties as reasonable men if it had been suggested to them. It must have been a term that went without saying, a term necessary to give business efficiency to the contract, a term which, though tacit, formed part of the contract which the parties made for themselves. So implied terms are terms which are part of the contract, even though the parties didn't mention them, even though the parties didn't write them down at any point, but the parties must have meant them in some unexpressed way. So they're not terms which the courts use to sort of fix a contract or improve a contract. That doesn't work. The courts would never do that. Instead, they are terms which the courts feel the parties must have meant or must have meant to have included without actually expressing them. So those are implied terms, and indeed there's different forms of implied terms. Implied terms can be implied by fact, they can be implied by custom, and they can be implied by legislation. And let's have a look at each of those categories.